Former President Donald Trump has taken the stand in the $250 million civil trial that threatens his sprawling business empire. The case centered around accusations that Trump, along with his two adult sons, inflated various Trump assets to get more favorable rates from banks and insurers. Trump and his children have denied any wrongdoing. And while Trump just took the stand about an hour ago, the judge has already accused the former president of treating this appearance like a political rally. The judge has urged Trump's lawyers a number of times.
Hey guys, Andrew here. So what just happened is absolutely significant. Trump has spent years selling supporters on a mythology that he dominates courtrooms, that judges bend to his presence, that his legal battles are showcases of his command. What millions just watched inside that Manhattan courtroom was the raw, unfiltered collision between that mythology and reality. That mythology crashed into a wall the moment Judge Arthur Engoron looked down from the bench and decided that the standard rules of American jurisprudence were going to apply in his courtroom regardless of who the defendant happened to be. What followed was not dominance. It was not command. It was a 6-minute spiral that ended with the judge telling Trump's own attorney to get his client under control, then cutting him off entirely and bringing the gavel down on the whole spectacle.
Donald Trump, much of this was included interjections from the judge, Judge Engoron, who already has fined him twice for violating a gag order for attacking a member of his staff. But for this instance of Donald Trump on the stand, it was condemnation for the judge for giving, in his words, a political rally and speeches and not answering the actual questions from the New York Attorney General's prosecutor.
The judge in this case, Judge Engoron, was visibly frustrated with Trump repeatedly during the course of his testimony, urging Trump's lawyers to get their client to answer yes or no to yes or no questions. And at one point, Judge Engoron warned Trump's legal team that if Trump did not change his conduct in the courtroom in terms of how he answered questions, he would draw negative inferences when it came to the scope of the penalty in this ongoing civil case. The footage exists, the transcript exists, and what it documents is something far more consequential than a bad day for a defendant. It documents the precise moment when the performance met the limits of performance and the performance lost. Let me set the stage properly because the context here is essential for understanding why this confrontation mattered as much as it did. This was the closing argument phase of the New York civil fraud trial, the case that struck at the very heart of Trump's carefully cultivated business persona. The allegations involve systematic inflation of asset values, the kind of financial misrepresentation that built the Trump brand over decades.
A New York judge now ruling that former President Donald Trump committed fraud and lied about his net worth for years. And according to the court documents just into us, Mr. Trump apparently, according to this judge, lied to banks and insurers, exaggerating his net worth to the tune of something like billions of dollars. This is all ahead of a civil trial that is set to begin on Monday.
The stakes were enormous, not just financially, but existentially, for a man whose entire identity rests on the proposition that he is a genius businessman whose net worth is exactly what he says it is. Trump wanted to deliver his own closing argument. That was his demand.
To Tom Winter, explain what the judge is saying here and its significance.
Right. So the judge is basically saying that the Attorney General for the state of New York, Letitia James, came forward with a civil complaint last year and said that the former president, through his businesses and his personal financial representations, committed fraud by overstating his personal wealth and the wealth of his properties.
He wanted to stand before the court and address the judge directly to make his case not through the careful procedural mechanisms of legal representation, but through the direct channel of his own voice. The request itself was unusual. Defendants in civil trials do not typically deliver their own closing statements. That is what lawyers are for. But Trump is not a typical defendant, and his legal strategy throughout these proceedings has consistently blurred the line between courtroom advocacy and political theater.
Fireworks in the courtroom. Donald Trump delivering his own closing argument in his Manhattan civil fraud trial today, facing the prospect of losing control of his namesake company and a massive civil penalty. Mr. Trump briefly took matters into his own hands, declaring himself an innocent man, delivering a nearly 5-minute speech, largely grievances against the New York Attorney General and the judge overseeing the case.
Judge Engoron was willing to consider Trump's request to speak. He did not reject it out of hand, but he imposed a condition, the same condition that any judge would impose on any defendant seeking to address the court directly. Trump's legal team had to promise that their client would stick to the law and the evidence.
Whom he accused of having his own agenda. All that forcing Judge Arthur Engoron, who previously resisted granting the former president permission to speak in closings, to call on Mr. Trump's attorneys to, quote, control their client.
They don't have any evidence against us. Millions and millions of pages, years of litigation, and all politically motivated.
The surreal scene in court today playing out just hours after police responded to a bomb threat at Judge Engoron's home.
No campaign speeches, no political rants, no introduction of new material that had not been presented during the trial. Just the facts of the case and the relevant legal standards applied to those facts. This is where everything began to unravel before Trump ever opened his mouth. His lawyers would not make that promise.
The judge having become a target months ago after deciding the heart of the state's case against Mr. Trump, his sons, and the Trump Organization, finding them liable for fraud. The Attorney General's office now asking for a $370 million civil penalty against Trump for ill-gotten gains, alleging his company intentionally exaggerated the value of some of its most well-known real estate properties like Mar-a-Lago and 40 Wall Street to receive better loans from banks.
Think about what that means. The attorneys representing the former president of the United States in a civil fraud trial, officers of the court bound by ethical obligations of candor and professionalism, could not assure the judge that their client would follow basic courtroom procedure if permitted to speak. They knew what he was going to do. They knew he could not contain himself within the boundaries the judge had set. And rather than give their word and watch him break it, they refused to give their word at all. The judge accordingly denied the request for Trump to deliver a formal closing statement. The lawyers would handle the closings as lawyers do in virtually every civil trial in every courtroom in America. That should have been the end of it. The traditional closings proceeded. The legal arguments were made. The case moved toward its conclusion. But Trump's team was not finished. Attorney Christopher Kesey rose and asked the judge once more to let his client speak. It was a second attempt at something that had already been denied, a procedural move that put the judge in the position of having to engage directly with the defendant about what he would and would not be permitted to do. Judge Engoron turned to Trump and asked him directly whether he would follow the guidelines that apply to every closing argument in every courtroom in this country. Trump's response was immediate, and it was not an answer to the question that had been asked. He launched directly into a speech about political persecution. He announced that he was an innocent man being targeted by forces that wanted to destroy him. He declared to the judge's face that the entire proceeding was a fraud against him. And then, in a moment of direct condescension aimed at the man wearing the judicial robe, he looked at Judge Engoron and said the words that will follow him through every remaining legal proceeding he faces. I know this is boring to you. Sit with those words for a moment. A sitting judge presiding over a complex civil trial, being told by the defendant that the proceedings are boring to him, as if the judge were a student nodding off in a lecture hall rather than a judicial officer exercising the authority of the state of New York. The condescension was personal, the dismissal was direct, and it was aimed at the one person in that room with the power to shut the entire performance down, which is exactly what happened next. Judge Engoron did not debate Trump. He did not engage with the substance of the remarks. He did not try to reason with a defendant who had just demonstrated that he had no intention of being reasonable. He turned to Trump's attorney, Christopher Kesey, and delivered a directive that every lawyer in that courtroom understood immediately. Control your client. 4 words that say everything about what had just transpired. Control your client. Not please speak with your client. Not perhaps your client might benefit from a recess. Control your client. The implication was unmistakable. The judge had identified a situation that was spinning beyond the bounds of acceptable courtroom conduct, and he was placing the responsibility for reining it in squarely on the shoulders of the attorney whose professional obligation it was to do so. Then the judge imposed a time limit. Trump had 1 minute remaining before the court would break for lunch. 1 minute to wrap up whatever he thought he was accomplishing. 1 minute before the gavel came down and the room went quiet, and the defendant, who had spent his entire public life insisting that he could talk his way out of anything, was told that his time was up. When that minute expired, Judge Engoron cut him off. Not gently, not with an apology for the inconvenience of judicial procedure. He cut him off and recessed the court. The proceeding ended because the defendant had made it impossible to continue without compromising the basic standards of order and respect that American courtrooms require to function. The judge did what judges do when defendants refuse to follow the rules. He stopped the proceeding and left the room. What happened next is just as revealing as what happened inside the courtroom. Trump had a choice. He could stay for the afternoon session. He could demonstrate that despite the confrontation, despite the judicial shutdown, he respected the institution enough to remain present for the remainder of the day's proceedings. That is what defendants do in ordinary cases. They stay. They sit through the parts that are not about them. They show the court that they take the process seriously, even when it does not go their way. Trump did the opposite. He skipped the afternoon session entirely. He simply did not return to the courtroom. Instead, he walked to a building nearby, a building he happens to own, and he held a news conference. Standing before cameras he controlled in a setting he controlled, he proceeded to attack everyone involved in the case. He attacked Judge Engoron. He attacked New York Attorney General Letitia James. He attacked President Biden. The news conference was the courtroom speech continued by other means, a political counterattack designed to reframe the day's events as righteous indignation rather than procedural defeat. The pattern here is not subtle. When the courtroom imposes limits, Trump seeks a more favorable venue. When judges demand compliance with rules, Trump attacks the judges. When the gavel comes down and the proceeding ends, Trump finds a microphone and an audience that will not cut him off after 1 minute. The sequence of courtroom to news conference, judicial accountability to political counterattack has become so familiar that it now constitutes its own genre of Trump legal strategy. But the strategy has a fundamental weakness that the Engoron confrontation exposed. The judge controls the courtroom. The judge decides when the defendant speaks and when the defendant stops speaking. The judge can direct attorneys to control their clients. The judge can impose time limits. The judge can recess the proceedings and leave the room. And none of that power is subject to appeal in the moment. The defendant either complies or faces consequences. And on this particular day, the consequences were public, visible, and significant. The broader context of Trump's relationship with the judiciary makes the Engoron shutdown even more significant because it is not an isolated incident. It is part of a documented pattern of attacking judges who rule against him, a pattern that extends from the lowest trial courts to the highest court in the land. Trump has called judges lunatics. He has called them monsters. He has used the phrase Trump deranged to dismiss any judicial ruling that does not go his way. He has used court losses as fundraising appeals and rally material, transforming legal defeats into political grievance in a way that no previous American political figure has attempted at anything approaching this scale. The most revealing dimension of this pattern may be his treatment of the judges he himself appointed. When the Supreme Court ruled against his tariff powers in a significant case, Trump did not respond with respect for the institutional role of the court or even with measured disappointment. He blasted the justices who ruled against him as a disgrace. He said he was absolutely ashamed of them. These are his own appointees, judges he selected and elevated to lifetime positions on the highest court in the country. And when they exercised their independent judgment in a way he did not like, he attacked them with the same language he uses for his political opponents. Think about the implications of that for American institutional culture. The president appoints judges. Those judges take an oath to administer justice impartially. They are not supposed to be extensions of the president's political will. They are supposed to be independent arbiters of the law. When the president who appointed them calls them a disgrace for ruling against him, he is sending a message not just to those particular justices, but to every judge in the federal system. The message is simple and destructive. Loyalty to me is the only standard that matters. If you rule against me, I will attack you regardless of your qualifications, your reasoning, or your relationship to my own administration. This message echoes through the Engoron confrontation because it establishes the baseline from which Trump approaches every judicial interaction. He does not walk into courtrooms believing that judges deserve respect by virtue of their office. He does not accept that procedural rules are legitimate constraints on his behavior. He views the courtroom as another arena for political combat and the judge as either an ally to be cultivated or an opponent to be confronted. Judge Engoron, by imposing and enforcing standard courtroom procedures, demonstrated that the institutional architecture of American law still has the capacity to impose consequences on defendants who refuse to play by its rules. The implications for American courtroom culture are profound and troubling. The legal system depends on a baseline of mutual respect between participants. Judges rely on defendants and attorneys to adhere to procedural norms without requiring constant enforcement. When a prominent defendant systematically refuses to adhere to those norms and is rewarded with political support for doing so, it weakens the informal mechanisms that make the system function. Every time a defendant turns a courtroom into a political venue and faces no meaningful consequences beyond a momentary judicial intervention, it becomes slightly more acceptable for the next defendant to try the same thing. The clash between political rally style and courtroom limits is perhaps the central tension of Trump's entire legal saga. The skills that work in a political rally, the improvisational rhetoric, the personal attacks on perceived opponents, the willingness to say things that traditional politicians would never say are the exact opposite of the skills that work in a courtroom. Courtrooms demand precision. They demand adherence to evidence. They demand respect for procedural boundaries. A defendant who treats a judge like a political opponent and a trial like a campaign event is a defendant who is fundamentally incompatible with the requirements of the legal system. Judge Engoron's response, the control your client directive, the 1-minute warning, the ultimate shutdown and recess, represents the institutional answer to that incompatibility. The institution says there are limits. The institution says the defendant does not get to run the room. The institution says that when behavior crosses a line, the proceeding stops. Whether that institutional answer is sufficient to deter future misconduct remains an open question. But on the day in question, in that specific courtroom, the institution held. The aftermath of the Engoron confrontation raises genuinely difficult questions about how far Trump is willing to go in undermining the courts if his legal challenges continue to produce negative outcomes. The civil fraud trial was one front in a multi-front legal war that encompasses criminal cases and civil cases across multiple jurisdictions. In each of those proceedings, Trump faces the same strategic choice: accept the legitimacy of the process and participate according to its rules, or attack the process as illegitimate and rally political support against it. The Engoron confrontation suggests that he has chosen the second path and that he will continue choosing it even when it produces public judicial interventions. The defenders of this approach will make arguments that deserve to be acknowledged. They will say that defendants in high-stakes cases sometimes legitimately express frustration with proceedings they believe to be unfair. That is true. The legal system is not perfect, and defendants are not required to be emotionless. They will say that judicial decisions sometimes reflect perspectives that deserve criticism. That is also true. Judges are human beings with their own backgrounds and assumptions, and they can be mistaken. They will say that political prominence sometimes generates a level of legal scrutiny that differs from the treatment received by ordinary defendants. There is evidence for this claim as well. But these defenses crumble when applied to the specific facts of the Engoron confrontation. Telling a sitting judge that the proceedings are boring to him is not legitimate frustration. It is personal condescension. Requiring multiple control, your client directives across multiple courtroom appearances is not a pattern explained by judicial unfairness. It is a pattern that reflects a defendant who refuses to adjust his behavior to the requirements of the venue. Skipping court sessions to hold news conferences attacking the judge is not political prominence generating scrutiny. It is a defendant prioritizing political messaging over legal obligation. And attacking even one's own judicial appointees as a disgrace is not reasonable criticism of judicial reasoning. It is a comprehensive repudiation of the principle that judges should exercise independent judgment rather than personal loyalty. The cumulative weight of these facts tells a story that the defenses cannot adequately address. The story is about a defendant who has made a strategic decision to treat the legal system as an extension of the political battlefield. The Engoron shutdown is a data point in that story, but it is an especially vivid one because it captures the precise moment when the strategy collided with an immovable institutional barrier. The judge said no. The defendant kept talking. The judge said, "Control your client." The defendant kept talking. The judge imposed a 1-minute limit and then cut him off and recessed. The defendant walked out and held a news conference. The pattern is clear, and it is not a pattern that strengthens the rule of law. What comes next for American legal accountability in the face of this sustained challenge depends on whether the accumulated weight of judicial responses eventually produces meaningful deterrence. Each individual judge can only control what happens in their own courtroom. Each judicial shutdown, however significant, is limited to the proceeding in which it occurs. The broader question is whether the aggregation of these moments, the Engoron confrontation, the control your client directives in other proceedings, the attacks on judges across the entire federal system, eventually triggers a more comprehensive institutional response. That response could take various forms. It could involve clearer and more consistently enforced standards for defendant conduct in high-profile cases. It could involve professional consequences for attorneys who enable rather than restrain their clients' courtroom misconduct. It could involve a broader public reckoning with the damage that is being done to the norms that sustain American legal institutions. Or it could involve none of those things, and the current pattern could continue indefinitely, with each new confrontation generating another cycle of political attention and institutional stress. The stakes of this question extend far beyond any individual defendant. The American legal system is not self-executing. It depends for its functioning on a widely shared belief that the rules are legitimate and that compliance is not optional. When a prominent figure demonstrates repeatedly that the rules can be violated without meaningful consequence, the belief that sustains the system weakens. Every time a defendant treats a judge with open contempt and then raises money off the confrontation, the system loses a small piece of the cultural authority that makes it work. What the Engoron confrontation ultimately represents is a test of whether that cultural authority still has force. The judge imposed limits. The defendant resisted them. The judge escalated. The defendant retreated to a more favorable venue. The institution held its ground for the length of a single court session. Whether it can continue holding its ground across the many sessions and many confrontations still to come is one of the most consequential open questions in American public life. The fundamental issue at the heart of this entire saga is whether American defendants should respect courtroom proceedings or whether they should feel free to bring political rally behavior into legal venues whenever they believe it serves their interests. Judge Arthur Engoron is not a politically motivated jurist manufacturing complaints against a Republican defendant. He is a professional judicial officer exercising appropriate procedural authority through his institutional position. The procedural requirements that Trump's lawyers refuse to accept are not politically motivated restrictions targeting a particular defendant. They are standard American legal procedural requirements applied to every defendant in every courtroom. The Control Your Client Directive is not a politically motivated judicial intervention. It is an appropriate professional judicial response to documented defendant misconduct. The judicial accountability mechanisms applied to Trump are not politically motivated institutional coordination. They represent professional judicial functioning through established institutional channels. All of these legitimate aspects of American courtroom functioning deserve respect rather than systematic attack. Whether American legal culture eventually produces an appropriate response to current patterns of courtroom behavior depends on whether accumulated judicial responses eventually produce meaningful consequences that affect how future prominent defendants approach courtroom engagement. The Engoron shutdown will not be the last such moment. The underlying dynamics that produced it, the defendant who refuses to accept procedural limits, the judge who insists on enforcing them, the political movement that rewards defiance with support are all still in place. The next courtroom confrontation is not a matter of if, but of when. And when it arrives, it will test once again whether the institutional architecture that held steady in that Manhattan courtroom can continue to hold steady